Good afternoon, everyone. Thank you so much for joining us today for another one of our WESC webinars. My name is Josie Fries, and I work for WESC. And today we are pleased to be joined by Rachel and Wuraola from Miller Thomson Law Firm. During this webinar, we'll be discussing how insolvency can affect you and your business. Thank you, Rachel and Wuraola, for joining us today. Please start whenever you're ready.
With you all here to talk about bankruptcy and insolvency and how it affects your business. So Rachel and I are just going to split this discussion. It will be quite conversational. Please feel free to drop your questions in the box and we will address those questions at the end of our presentation. So the overview generally, we'll talk about bankruptcy and insolvency, generally the definition, what it means, filing for bankruptcy, and how that impacts you and how it impacts your business depending on what the situation is. We will also talk about the alternatives to bankruptcy. If not bankruptcy, then what? Debt recovery from insolvent and bankrupt third parties, meaning if you have a client or a customer who is insolvent or who is bankrupt, how do you deal with them? Then finally, we'll just kind of wrap up the conversation with things that you can take away and hopefully apply to your business and to your day-to-day operations. So basically, insolvency means you are unable to pay your outstanding debt as they become due. I remember when Rachel and I had a chat about this and had this presentation earlier to some of our clients. She did mention that if you're a fresh graduate with student loans, you may be considered insolvent, but then it doesn't mean you have to proceed and file for bankruptcy because almost every fresh graduate with student loans would have a lot of debt and probably be unable to pay their student loan once and for all, which makes sense. But then bankruptcy is a different thing entirely, and it means that you are quite at a point where you are making an assignment or another of your creditors, meaning somebody that you're owing, a corporation, a bank, an individual, is making an assignment on your behalf and trying to get a bankruptcy order. It's solely a court proceeding, so this is not just something that a creditor can wake up and decide to do. Generally, the idea is that if you cannot pay your debt and you have also stopped paying your current obligations as they become due, and also the fair market value of all of your assets exceed your liabilities and obligations, then maybe you are insolvent, and maybe depending on how serious it is, maybe bankruptcy can be a thing. So generally insolvency precedes bankruptcy because you must be unable to pay your debt first. And then at that time, you may consider whether or not bankruptcy is declaring bankruptcy or filing for bankruptcy is an option for you. It's a federal legislation that governs this area. It's called the Bankruptcy and Insolvency Act. And it's funny that the act actually defines an insolvent person as a person that resides, carries on business, or has property in Canada and owes more than $1,000. So the threshold is really low, meaning you owe more than $1,000. But then a lot of other things will then come up, like whether you're unable to meet your obligations as they become due, whether your assets cannot pay out or pay off your liabilities. I will turn it over to Rachel now as she talks about filing for bankruptcy and how that impacts your business.
Hi, so Rachel here. As Wuraola said, there's a couple things you need to consider before you file for bankruptcy, and we're going to get into some details on some of those. So firstly, you have to understand your debt situation, and by that, Wuraola brought up a good example. Not every debt situation warrants a bankruptcy. There are certainly situations where you have, incurred, or your business has incurred good debt in the sense of, a mortgage, something to that effect that is going to give you a long-term value. And then the question really becomes, do you have the cash flow or the resources to service that debt in a sustainable way? And if the answer is yes, even though on paper you may be insolvent, can't pay it all immediately, potentially you don't want to file for bankruptcy in those situations. Another big consideration is the legal status and obligations of your business. If you are a sole proprietor and that's the way your business is being managed, bankruptcy will impact you personally, even if the bankruptcy and the insolvency arose from your business. And so that's something you have to be mindful of then, because that will affect, for example, your credit score, your personal credit score for 7 years. It'll impact a number of different things. So that's always an important consideration, is how have you set up your business from the get-go will impact the types of concerns and considerations that you would have in respect of bankruptcy. And, you know, in terms of some good first steps, you should speak to your lawyer or an insolvency trustee. It's always possible that you might be able to restructure some of your debt as opposed to, you know, making an assignment in bankruptcy. Restructuring can be in a number of different ways. We often do things such as forbearance agreements, where your creditor, if they see your long-term potential or the long-term potential of your business, and you have some money, maybe not today, but 6 months from now, you have some sort of contract, for example, that you know if you can just stay afloat for 6 months, you're going to have this strong cash flow coming in. Often your creditors will, you know, at least be enticed by the potential revenue that you'll have coming in the future to say, okay, well, maybe we'll put, you know, the brakes on, you know, pursuing you for your debts for those 6 months. And that would be a form of a forbearance. You know, the creditor is going to wait 6 months. Usually you have to give, you know, some sort of information or a payment to them to sort of entice them into those types of agreements. But that can be a good option other than, you know, having to file for bankruptcy. And again, a lawyer or an insolvency trustee can help you sort of navigate that framework and make sure you're in line with those options and that you've explored those options before you consider bankruptcy. Another reason why you might want to speak to a licensed insolvency trustee or a lawyer is because often people with closely held businesses where your employees or, you know, the people who are running the day-to-day business are your family members, your friends. You know, you're starting out and you're relying on support internally. It's possible that you might be running into concerns about fraudulent preferences. And what that is really, since 1571, which is when the British Parliament first made legislation on this, essentially, you're not allowed to transfer your assets to, you know, other creditors favoring certain other creditors. So an example would be, let's say you have a credit union who's your creditor, and you also have, you know, the TD Bank, who is one of your creditors. You're not allowed to, if you're insolvent, pay out the TD Bank first just because you like them better than the people you're dealing with at the credit union. The credit union can actually sort of attack that and say it was a fraudulent preference. And that's the case even if you're arm's length to all of these entities. But it's especially the case if you, for example, got your husband or your wife working for you and you've been making payments to them, even if it is salary. Well, someone might look at that and say, well, is this a genuine payment that all this money has been flowing out of my business? And they can look at that potentially as fraudulent preferences as well. So it's important at the outset that you're really documenting these types of relationships. Like if you are actually hiring your spouse as an employee, you want a good agreement to help you show they are an employee, they're working 40 or 50 hours a week here, this is their hourly wage, and something in writing like that can actually really help you in the event that you're staring down an insolvency or a bankruptcy. And in terms of the legislation that you'd have to be careful of in in respect of fraudulent preferences, there's really two main ones. I did reference the 1571 British statute, which is technically still law in Canada, if you can read through all the crazy, old English, which sometimes we have to do. But the main ones are the Bankruptcy and Insolvency Act. It has two provisions. One deals with preferences, which again is making payments to people who are either arm's length or not arm's length to you. And those can be looked at for a 3-month period if you are dealing with the other parties at arm's length, but they can actually go back an entire year and look at all of your non-arm's length transactions in a bankruptcy. So again, if you paid your spouse a year's wages, it's potentially going to be criticized or looked at by a bankruptcy trustee if you're going down that path in the future. So it's good to sort of consider that in advance, plan accordingly. Like I said, if you have good paperwork ahead of time, it would just make your life much easier if you are having to consider bankruptcy or insolvency. And the second statute, which is a Saskatchewan piece of legislation, is the Fraudulent Preferences Act. And it has very similar provisions in terms of, arm's length, are you not arm's length? That's sort of the key thing that differentiates the timeframes that you're looking at. And additionally, under the Bankruptcy and Insolvency Act, there's always an opportunity for anyone, if you were to file for bankruptcy, to criticize any transfers of assets that you or your business had made. So again, let's say you own ABC Company. Well, ABC Company had, sold to your spouse, a boat. Your spouse wanted to buy the boat. He bought the boat. Well, if there's any question that he paid less than fair market value for the boat, it's possible that in bankruptcy, there could be a repossession of the boat and, some concerns with that. And that can all be sort of criticized as soon as you end up in this insolvency bankruptcy situation. So again, before you actually, file for bankruptcy, it's good to have a discussion with someone and make sure that you either haven't, put yourself in a situation of having fraudulent preferences, or if you might have done so, that you have some good advice on how to handle those situations and how to navigate that sort of difficult period. Now, in terms of filing for bankruptcy, obviously you need a trustee. They become the legal owner of your stuff on your behalf, but really the way the Bankruptcy and Insolvency Act reads, you don't technically legally own your stuff anymore. In bankruptcy, the trustee has it all. They get to do what they want with it, subject to the exemptions that you're allowed at law. And you do have to give them a number of, some personal information about you. It would include things like your name, your address, your birthday, your social insurance number. They need a list of all your creditors, and that as well is important that you are listing everyone who is a creditor of you, and that you're not sort of trying to make things look better than they are. They're going to find out because this is going to be going through a court process, and other people who aren't listed in your list of creditors could still potentially talk to your trustee in bankruptcy and say, actually, they owe me money too. So there's an aspect of this that you just have to sort of bite the bullet and be truthful and accurate about everything. They need a list of all your assets, and that, again, is going to be very detailed. And the implications of your assets will be impacted by how you had structured your business. If you had incorporated, for example, and your corporation is in bankruptcy or is making the filing for bankruptcy, only its assets have to be listed. Your personal things don't get roped into that. If you have a sole proprietorship, you're looking at your personal assets as well. And again, there are some exemptions that you're entitled to, such as your primary residence to a certain amount, but certainly it becomes a little more nerve-wracking if you have to, list out for your creditors your personal assets because you have a sole proprietorship type of business. So that's something just to be mindful of when setting up your business structure. And lastly, you have to do a questionnaire and just be generally cooperative with the trustee.
Thanks, Rachel. So I'll just proceed here and talk about the impact of, no, we should be talking about something else here. Okay, just before we proceed and talk about the impact of filing for bankruptcy, I will just, yeah, this is what I was looking for. Apologies, everyone. Alternatives to bankruptcy. So generally, you should first of all talk to your advisor, your business advisors, your financial advisors, and your legal advisors. And these options are just 3 out of many, and they would vary depending on your factual circumstances. So they're not quite cast in stone, but there are a few things you should do. But first of all, I believe that the lines of communication should be open with your with the lenders and with your creditors generally, because when the creditors see that they're quite in a bad situation and you are unable to make your payments as they become due, sometimes if you are quite forthright with them and open, they're willing to get into some kind of arrangement with you where they don't have to enforce, they don't have to deal with all of the steps that would come with all of the steps and sometimes the headache that will come with enforcement. This is more so with unsecured creditors. With unsecured creditors, it means that you owe them money, but they do not have a specific security. So it's not like they registered your RV, they took security in your RV and registered that at the personal property security registry. And once you default, they can go take the RV and sell it and apply payment, So unsecured creditors generally do not have some kind of security that they can take once you default. So I find that unsecured creditors are open to having discussions with you about debt consolidation, debt refinancing, like Rachel earlier mentioned, some kind of repayment arrangement or forbearance agreement where they say, we are going to forbear from taking enforcement actions for a couple of months and see if you can come up with payment. Specifically, again, for unsecured creditors, when it comes to debt recovery, and Rachel will go into this a little bit more in detail, the process is long. They have to file a statement of claim. Depending on the kind of business you do, they may have to give certain notices, and then getting a statement of claim, getting a judgment, enforcing and trying to collect money after the judgment could be a long process. It could take 12 to 18 months. And so you would find that if you open the line of communication with your lender, especially the unsecured creditors, they would be happy to have some kind of discussions with you. So your line of credit is probably unsecured, but you can also consider debt consolidation where you're adding that debt to your mortgage and where you're having discussions about the interest rates. How can we restructure the entire debt load such that I can have lower interest rates, because even with the current interest rate, I'm defaulting, So just those kind of conversations, and maybe having advice of your business advisors or your legal advisors prior to that discussion with the lender may just put things in a little bit of more perspective, especially when you also give them numbers, statistics. These are your plans to pay out the debt. You may be able to find a willing and patient lender that will just kind of consolidate the debt or refinance the debt even. When you're dealing with multiple creditors, an option is to actually still have discussions with both of them. There is something called inter-creditor priority agreement. So basically, the credit union, I'll use the example that Rachel used, the credit union and the TD bank, basically you owe both of them, but you want to collect more money from the credit union so that you can pay out some of the debt of the TD bank. You can have both parties entering into an inter-creditor financing agreement where one of your creditors is saying, we are going to take security in A, B, and C up to a maximum of 50,000, and the other person will kick in and take the rest of the security. So basically, they're kind of apportioning the priority of the security and talking about who you have to pay out first, or if you have to continue to pay both of them at the same pace during the same period and all of those kind of things. Also, if you're dealing with multiple interest rates, multiple loans, consolidating your debt may just really help you to simplify the entire debt load such that you're only dealing with one or two creditors rather than 10 or 7 creditors on multiple moving parts. So you may pay out the higher interest rate loans and then just have to deal with the lower interest rate loans or the friendly creditor, as the case may be. Number 2 is the consumer proposal. I think I have talked about the consumer proposal and the debt consolidation sometime in an interwoven manner. So basically, you're having a proposal, you're presenting the numbers. Sometimes your insolvency trustee would assist you, depending on how far gone you are. I mean, you can also have the trustee just help you with the old alternative and not just with the bankruptcy process itself, because they are experts and they kind of know how things can go if you file for bankruptcy. So they may also be able to navigate the terrain of the alternatives and see if they can make proposals to your creditors, and the creditors can give you more time to pay off the loan. You're presenting the numbers to them, you're giving them the statistics, telling them how feasible and how realistic your payment can be. Again, these would all depend on the factual circumstances of your business, of the debts, of your past defaults or your past compliance and all of that. Then there is the CCAA restructuring. So this is called the Companies Creditors Arrangement Act, and it's generally for insolvent corporations owing their creditors in excess of $5 million. So it's quite a different process. It's not a regular or a typical kind of court proceeding, and this is usually done through a court proceeding where you have a lawyer, the creditors have lawyers. You're basically before the court to restructure it's still restructuring of your debt load. It's about what property should we sell, and you're having the court kind of veto that. You're having the other creditors agree, and if they do not agree, you're having the court to make a decision on that. So it's like, what property can we sell so that we can pay out this debt? What property does the corporation need to continue to function and to continue to have a good business? So basically, it's an alternative to the corporation going out of business or being struck off the registry or dying. So it's like just seeking the protection and seeing how you can restructure. If your business is diversified, it's more like, what business should you which one takes a lot of your money and which one should you kind of focus on? So again, these are things that would be so factually based. The intricacies would depend on the step you take would depend on the intricacies of your situation, your debt load, the kind of creditors you have, the kind of your legal status as a sole proprietor, as a partnership, or as a corporation. Of course, a sole proprietor or partner a partnership arrangement would not even be able to take advantage of the CCAA protection. So those are just 3 out of the alternatives. Again, we generally recommend talking to an advisor and also carrying your lawyer along, because sometimes you'd have to get some documents drafted. So having your lawyer involved from the get-go will just make sure that all the loose ends are tied and you are on the path to being out of debt, basically, or cleaning up the bad debts. Over to you, Rachel.
Thank you. So I'm just going to jump back to the impact of filing for bankruptcy. Sorry, those slides are out of order there. So let's say you consider all the options, you've considered the other options that Wura just presented, and you still decide, bankruptcy is the best way to go. Some of the key impacts of filing for bankruptcy are those listed on this slide here. So as Wura said, there are generally 2 categories of creditors that you might have. The unsecured creditors are the people who you might owe money to, but they don't actually have any interest in any of your personal property or your land. So, if you basically got an asset like a boat from someone and they just didn't take any security, that would be unsecured. Things like, if you have a mortgage, the mortgage is security, so your creditor who has that mortgage would be a secured creditor. And those two types of categories get treated a bit differently in bankruptcy. So you can't have enforcement by your unsecured creditors, like the people who you just owe money to, any further during bankruptcy. Your secured creditors, though, can proceed to seize and sell anything that they have security in. So again, if you had a mortgage, the person who has your mortgage could foreclose or could try to sell that land in the appropriate channels, and they'd have to follow their own processes, but the bankruptcy doesn't prevent them from doing that. Similarly, if you're leasing your car, that could be repossessed and sold as well. So bankruptcy doesn't protect you from your secured creditors as much as your unsecured creditors. You might lose your non-exempt assets. So again, your bankruptcy trustee owns your stuff now. If they say, hey, you have 5 cars, you're only allowed an exemption in 1, they'll sell the rest of your cars. And you can't really do anything about that if you don't have an exemption under law. If the bankrupt entity is a corporation, it can be struck off the register. So it's going to be no longer a valid corporation in Saskatchewan. If the bankrupt person is an individual, then they cannot act as a director of a corporation. And so that can really affect you as well if you're considering, if you already have a corporation and a sole proprietorship and you're thinking the sole proprietorship needs a bankruptcy, you have to be mindful of, that might impact your ability to be a director of your other corporate entities. Now, looking from the other perspective, let's say your business is doing just fine. You don't have any insolvency or bankruptcy issues, but someone who owes you money does. What do you do? Well, the first thing you have to do is consider, are you secured or unsecured? When you were giving services or goods to this, bankrupt party, did you take security? Did you register in the Saskatchewan Personal Property Registry against the boat that you gave them? For example, if you haven't been paid in full for the boat, we would always encourage everyone to register and to be mindful of these things at the outset. I do a lot of commercial litigation, and often by the time I see things, someone's already in bankruptcy. But if you have some forethought ahead of time and think and treat your business as, I need to protect my business and protect myself by taking security in, large value items that I'm going to be selling or in services that I'm going to be provided, especially if they're a large value, that can really save you a lot of heartache. Because often what I see regularly is, friends who both have businesses and they haven't taken security in each other's stuff because they think, oh, Sue is good for the money, I don't have to worry about Sue. Well, then Sue's business ends up in bankruptcy and you have maybe 6 figures worth of unsecured debt that's owing to you by Sue, and you're not going to get that money through the bankruptcy generally. Usually you get, sort of a few cents on the dollar that you're owed if you're unsecured in bankruptcy. Because again, the whole point of bankruptcy is they don't have enough money or they don't have enough assets to meet their debts. And the unsecured parties are those who suffer the most. Because if you have your security, you can go and take your boat back, you can sell your boat, you can apply that to what's owing to you, and at least you can say, I know the value of this boat, I'm at least getting this boat back. The unsecured creditors, it's sort of what's left over, which in a lot of cases isn't a lot of money. Now, if the third party entity is bankrupt before you've taken any proceedings to collect anything from them, then you have to file what's called a proof of claim with the trustee in bankruptcy. It's basically a form. You have to attach the supporting documents that show, how much they owe you, and you submit it to the trustee in bankruptcy. They give you your cents on the dollar once they've gone through making sure everyone who has priority over you gets paid. If you have a situation where, say, you've started to try and collect on a loan previously, you've probably done that through like a statement of claim, court, or a demand letter. Those are good options in terms of trying to collect things before someone becomes bankrupt. The limits right now, so if you wanted to issue a claim in small claims court, you could do that for anyone who owes you or your business less than $30,000. And if it's, $30,001 or more, you want to go through Queen's Bench Court. And, again, another thing we would always recommend is if you're seeing a pattern of a particular person not paying you and not, responding to your invoices in a timely fashion, consider terminating your services or, making them give you security for the amount that you're owed. And again, all too many times we see this with families or friends who have businesses that are related. And unfortunately, people don't take the same protections in those situations. But you just have to keep in mind, it's like, this is your business. You've invested a lot in your business, and you don't want, Sue's business going bankrupt to sink your business, because you don't have money then to service your debt obligations if Sue owes you, 6 figures and you're sort of waiting for Sue to make payments to you. So we really just encourage, they can be difficult conversations, but certainly, we think it's worth it to have those conversations, because again, you've all put blood, sweat, and tears into your business, and it's just, heartbreaking for us to have to see how often that, someone like your aunt or your friend end up, resulting in you not getting the money for the services that you've provided to them. And once they've filed for bankruptcy, it's too late to take the security. And that again ties into the fraudulent preferences thing. If you're waiting until they're in a really bad place before you have those conversations with them about taking security or about having you get paid prior to other people, then it's possible that people will say, well, this is a fraudulent preference. Like if Sue comes up with $100,000 to pay your business and then files for bankruptcy the next day, every other creditor is going to come to you and say, you have to give us the $100,000 back. Sue gave it to you because you're her friend. So it's important that you're, monitoring these things on an ongoing basis and doing really everything you can to make yourself secured, or make sure that you're not sticking your neck out too far in terms of like a dollar amount or a services perspective for any one individual. And some types of security don't have to necessarily be, things like registering in personal property in the Saskatchewan Personal Property Registry. That's one option. That's usually a common option, because personal property, things like cars, boats, etc., they're quite easy to search, even for a layperson. You just go to Information Services Corporation. If you have a serial number, you just plug that in and you can see, whether anyone else is registered. And if no one else is registered, you can say, okay, I want to register against this, and you just do up a basic, security agreement, and then you have a priority in that car or in that boat. But other types of things that you might have security in could be a lien on the property. If you're a construction entity doing construction work, if you provide materials or services, usually you are entitled to a builder's lien. So it's not just that you're there, physically pounding nails. If you've provided drywall materials to a site that get installed, you might have a builder's lien for those amounts. And then that can be registered against title, which is, again, more powerful for you in terms of trying to get you paid. Landlords, if you're a landlord, you could distrain against any goods that are in the property that your tenant has. And there are certain exceptions to that, but that's always a good option is, don't let them move out if they haven't paid you. You might be entitled to actually go in and seize some of those assets. And if you have a purchase money security interest, so if you supplied, the goods basically on account for them, maybe it's a lease to own agreement for a boat, then you get sort of an extra boost in terms of your priority position in bankruptcy. So those always give you a little extra in terms of, if people are fighting over assets during a bankruptcy, you tend to be in a better position if you've supplied it. And lastly, if someone looks like they might be getting into an insolvent position, you can always, as I said, just consider a forbearance agreement or having some sort of security agreement put into place after the fact within reason. You do just have to be careful about those timeframes for fraudulent preferences. But, it's often worth having the security put in place and letting someone else criticize it as opposed to not having it and not having that protection at all.
Yes, just before we go to the next slide here on the key takeaways, I'm just going to add to what Rachel talked about regarding taking security. Prior to taking security, the first thing you want to check, the first thing you want to do is to run a personal property search on that individual, on the borrower or the debtor, as the case may be. And this is because if you were interested in taking security in their car, for example, and the car dealership has a purchase money security, has an interest in that, in the same car, they would have priority over your own registration. And when you find out, or when you dig a little bit further down into what's happened with that security, you may find out that there is no equity in the property, and so your registration is just basically in vain. And again, usually the first in time rule applies when it comes to priority. There are certain exceptions. There are the CRA super priority registrations where that's totally a different purview generally. But if you're dealing with a regular day-to-day individual and you have another creditor that's taking security in their property, then you want to make sure that you've gone to do a personal property search. If it's land, if you want to take a mortgage in the land, you want to make sure that you have done a land title search to see if they own the land free and clear of all encumbrances. You also want to make sure that you've done a bankruptcy and insolvency act search on them, because if for some reasons they've given a bank act security if they've given a bank act security to a bank, it's going to affect what you can take in that same security. And you also basically, like, bottom line, want to do a bankruptcy and insolvency search on them. Like, basically all of these things have searches where you can basically pull what you can pull information, and they're public searches. You can pull information on the debtor and understand what's happening to them. As an individual, you may not be able to pull the searches because you probably need some access, or you need to have some kind of account. But if you talk to your lawyer, they should be able to pull all of the searches for you and see what's happening with that person. So do a bankruptcy and insolvency act search to see whether they've declared bankruptcy or filed for bankruptcy in the past couple of years. Do a bank act security check to make sure that they haven't given a bank some kind of security, because the bank act security takes super priority position as well. Do a PPR, personal property registry check, just before you take that next step and say you want to take security in their property, so that you can have good title to whatever security you are taking. Also, you want to make sure that you're considering the kind of debtor or the kind of borrower, whoever this individual is. the kind of business that they do. For example, there are certain obligations and certain rules to follow if it's an agricultural corporation or if the debtor is a farmer, and if you were thinking of taking some kind of security in their tractor, or even if it's a small farm equipment and you feel, oh, it wouldn't hurt them, it wouldn't hurt their farm, there is the Farmland Security Act and protection generally that's offered to farmers. And so there are just a few of these things. So it's not just about saying, oh, I'm going to take security and I will be fine. You also want to make sure you have good security and you have good registration.
Yeah, thanks for that, Wura. That's a good point. All of this, that we're providing is an overview, but Wura has just pointed out there's very good exceptions for things like farms, land, farm equipment, agricultural implements that are a little harder to repossess than other types of assets. So that's really where you want to, if you have a very specific situation, get some further advice on that, because it's quite a sticky thing for even lawyers to navigate sometimes. And there's cases where the court disagrees with something that even a lawyer had done to repossess because they weren't sure if it was a farm asset or not. So all of this is just very broad overview, but certainly some good, key takeaways for you guys. So just getting into, again, the high level takeaways from today is, first, make sure you're keeping an eye on your debt load. Keep records of all of your agreements with suppliers, with vendors, with clients, with your employees, again, especially if you're having people of your family work and you're going to be paying them. It's just helpful to have that in writing. Written contracts, very important. If you were able to do a security agreement, we always recommend that you try to take security for larger value things if you're supplying goods or services. And you should always review your debt documents before you sign them so that you're aware of your obligations and aware of things such as, if the interest rate might change if you fall into default, if the interest rate might change in a 3 to 5 year period. All of that is very important for you to review when you're entering those types of agreements.
Yes. And in addition to that, in reviewing your documents, the most important thing is actually reviewing before even signing the document, understanding your obligations, because you may be signing an agreement, a loan agreement, on behalf of your corporation as the debtor, meaning the corporation is the debtor. But there could be a clause in there that says there is also the personal guarantee of the directors. And you probably have maybe another couple of clauses talking about the guarantees and the personal obligations of the directors. So you may be appending your signature in your capacity as director of the corporation, but you may also be appending your signature in your personal capacity, meaning you are saying you're personally liable for the debt. And as a guarantor, basically the creditor can come after you. You'll be added to all of the statement of claim, the actions, the demand letters, every notices, enforcement. You would be treated the same way the original debtor is being treated. And so this is also good advice to you generally before you guarantee the indebtedness of a third party, of a friend, before you co-sign a mortgage where you are not a spouse of that person. I mean, that can be a very, very technical area because people co-sign mortgages also for estate purposes. But just on the loose side of things, when it comes to taking security or being responsible for the obligations of a debtor, you just want to get a lawyer for those 2 hours or for those 3 hours, which could be the best well spent and the best time you've had to spend your money on debt documents, because you may not know the implication of signing the documents. Also, if it is a corporation, and really many people would incorporate a corporation because the liabilities of the corporation would end, the obligations would end with a corporation, except you've given a personal guarantee. But if the corporation becomes insolvent and it cannot pay its debt as they become due, the directors do have a statutory obligation to act in the best interest of the company's creditors. So again, this is similar to the fraudulent preference that Rachel earlier talked about. A director may actually be personally liable for the debt of the corporation if the company is insolvent, or if the director goes ahead to make certain kind of payments. For example, the director declares dividends, or the directors, as the case may be, if they declare dividends and have the shareholders take some money when there are creditors that should be paid out, then the directors may be personally liable even after the company has gone bankrupt. Also, if you continue to trade without the intention of repaying creditors, if you carry on business and you continue to assume more debt without intention of carrying on business, basically the court would maybe look into the intention. And intention is a hard thing generally when it comes to this thing. So it would be a question of what has been your track record? Why are you taking this loan? Is there an element of bad faith in this? Did you do this in good faith? Were you trying to save the corporation, or were you trying to save your own pocket, or were you trying to act in the best interest of the debt of the creditors of the corporation? If as a director, your company is insolvent and you are selling the assets of the company for less than the fair market value of those assets, then that could also be a red flag, and you can become personally liable for the indebtedness and the obligations of the corporation. So remember that at this stage, the corporation is just insolvent. It's not even bankrupt yet, because once it becomes bankrupt, then technically all of the assets and everything that the corporation has would become the trustees legally, and the trustee would administer the property. But this is even just at a point where the corporation cannot meet its obligations as they become due. Every sale of company assets, every dividend that you want to declare at the time, every creditor that you want to pay at the expense of other creditors, all of those actions will come under scrutiny, because other creditors may see that there are elements of bad faith and you've acted in a way that's prejudicial to them. So a corporation, ideally, the corporate veil wouldn't be lifted such that shareholders or owners will become personally liable. But when there are instances where there are red flags, a director can be personally liable. So you want to watch what you're doing on behalf of the corporation when the corporation is insolvent. As Rachel mentioned, you should have written contracts. We can't say this enough. Make sure everything is in writing. Make sure you have contracts, good contracts, well-written contracts. Explain the position and the situation to your lawyer. This is what services you provide for this person, and this is why you want to take some kind of security. Or this is even just the service agreement. So a service agreement or another agreement for like a contract for your services would typically have a default provision where it talks about the event of default. So the event of default are basically things that once they happen, that would trigger your abilities to collect if you are the creditor, if you're the one being owed. So you want to make sure that those clauses, the event of default, and the fact that if you're providing a cure period for them in the contract as well. And a cure period is basically they have defaulted, but you're giving them 15 days to remedy the default and make everything good, and you can continue as though that did not happen. So you want to review the cure period and see if, based on the kind of services you provide, if 30 days is a reasonable cure period, for example, and if you should continue to provide your services. It would basically depend on your circumstances, the kind of business you do, the kind of clients that you have. Your contract would also generally talk about, it would have the dispute resolution clause or provision that says, I can take you to small claims court, or we can try to mediate, like we can try to use ADR. For bigger contracts, you may have things that say we can try to use arbitration if the debt is up to a maximum of 500,000, or if it's less than. You can have all of those thresholds depending on what your goals are, whether you want the litigation or the collection process to be public or private. You can have all of those clauses all woven into your contract. Finally, if you are taking security in the property of a debtor, you may want to consider giving them an opportunity to obtain independent legal advice. The reason this is important, I mean, ILA is not statutorily important, is not statutorily necessary for regular day-to-day security agreement. But if you're taking a security in farm equipment, again, those are regulated industries. So you want to, there's a provision that says there must be an ILA, and if there is a waiver of an ILA, there must be a document to support it. So you have all of those kind of things where you just want to make sure that even if there's a waiver, if there is a statute that talks about those kind of transactions, you want to make sure that you can legally waive their right to obtain independent legal advice, ILA. So generally, we still say for enforceability of the contract so that the creditor would not, the debtor will not come back later and say, oh, I did not know what I was signing. I did not know I was giving you security interest in my RV. You know, we signed it at the kitchen table. I was under pressure. You didn't allow me to review the contract. Therefore, you can't collect the RV because it was an unconscionable transaction, or it was I didn't have an opportunity. I didn't sign it, or that signature is not mine, or I was signing it, but I didn't know what I was signing. So just to take away all of those doubts and all of those potential issues, you may want to give them an opportunity to actually take the contract home, even advise them to take the contract to their lawyer, and even then have your lawyer include a clause. The lawyer would probably do so if you've explained the situation to them very properly. Have them include a clause that says, we have obtained or we have decided to waive our option to receive independent legal advice. You know, you can even have a tiny box just beside that clause where they are specifically checking that box and initialing that box to say, you brought their attention to this particular clause. You told them to obtain independent legal advice, but they waived their right to do so. So that at the end of the day, when the contract has to speak for itself and when these people are in default, you can go back to that contract and say, you did initial this clause. You were aware that you had an opportunity to get a lawyer, but you chose not to. So now you can't say that it's an unfair contract, or you can't say that you did not know what you were signing. So basically, that's the gist of the entire discussion today. Thank you very much for your time. Rachel, anything to add?
I think let's see if anyone has any questions.
Yeah, if you have any questions, please feel free to drop your questions. We're just reading through the notes here in the chat room, and we do not have any question yet. But if you do have any, we're still here for another couple of minutes, 6 minutes, and we can take your questions.
All right, it looks like there's no further questions, so we're going to go ahead and just end the webinar as is. If there are any questions at the end of the presentation, or if you're watching this on demand on our website, you can always email us at info@wesk.ca, and we can try to get some answers for you. Otherwise, thank you so much, ladies, for doing an awesome presentation. We've learned some great information today, so thanks for that. As I said before, I want to let everyone know that this webinar will be available at wesk.ca within a couple days. So you can always revisit our website and check back for some information later. Thank you all for joining us today. Our next webinar will be on July 17th. And again, you can find that info on our website. Thanks everyone for joining us. Have a great day.